met, my name is Dan Regard. I'm the CEO of iDiscovery Solutions. It's a pleasure to keynote today because I was given the opportunity to keynote at the very first Masters almost 15 years ago. It was spectacular. So it's been a great journey for everybody, I think we would agree, through this industry. And lots of changes. And we're at the cusp of a new change, I would say, now. Because of the years I've done this, my background in computer science and mathematics, the advent of technology in the world that we deal with today, my clients come to me often and ask the question, what if? And we ask the question, what if we could tap into the digital universe, the computers around us? What if we could replay any moment as a digital narrative? And what if, as lawyers, we knew in advance who to depose and what to ask? In fact, shocking to this room perhaps, what if we could conduct litigation with no email? Well, we might not use that picture, right? All of this is the promise of big data. And all of this can be done because I've seen it happen. The question today is when, where, and how. Every day we create 2.5 million bytes of data, and we know that this is an old number. We also know that it's going to get worse, a lot worse. Typically when people say, why will it get worse, there's one answer, 5G. 5G promises to allow us to electronify everything we could possibly imagine. And if you've done any type of looking at products that have been released, from automobiles to self-censoring seats to children's toys to Fitbits ad galore and wearables, you know that this is true. We are digitizing every aspect of our lives, and this body of evidence is what this room will be dealing with for the next 15 years. How are we going to do that? Well, let me give you some perspective on some cases. We worked on a case recently for wage and hour where the parties litigated through the pleadings phase for 8 years. The defendants won the case twice. It was remanded twice, went all the way to the state Supreme Court, finally got ready for litigation. We went forward. They had never looked at the data. When we looked at the data for the 51,000 people, this says 53,000 pay stubs. It was actually 484,000 pay stubs, 53,000 that had noticeable underpayment. The totality of all the underpayments for 484,000 pay stubs was $15,000. They should have looked at the data when they started. No emails were necessary for this case. Another case involving 11,000 drivers. They litigated for 7 years. After 7 years of winning the case and having it remanded and winning the case and having it remanded, it went to trial. In 12 weeks, we identified and collected 90 billion records from 40 different archives, 20 different systems, 40 systems, and in those 12 weeks helped resolve the entire case. If they had looked at the data earlier, they could have avoided 7 years of litigation. There were no emails at all in the resolution of this billion-dollar exposure. Now, these are outliers, but are they the canaries in the mine that tell us there is a new type of evidence that can be so dispositive we need to consider it in the cases we work on? Let me give you a more detailed example of a wage and hour involving appliance repairmen. We received data in this case because the plaintiffs were very savvy and they asked for it. We helped produce it and therefore were also asked to analyze it. From Windows, internet history, the information IT on when they checked inventory, their operations and dispatch, the fleet management GPS, invoices to clients, personal detours, and when they entered their time. These are for people who drove vans to repair appliances in the field nationwide. When we analyzed this data, we were able to take the legal questions in that case. Did they work at home sufficiently to trigger compensation? If they triggered compensation, how much time did they spend before they were officially on the clock that needed to be compensated? How many days met these conditions? When we analyzed those issues, programmed them into the data, we came up with these answers. The system said, this is the day you need to look at. This day is where they did not log in for more than 10 minutes. It was less than 10 minutes. And in fact, they logged in after they started driving, which is unusual since they didn't know where to drive. And in fact, they started driving after their first repair job, which is difficult because there's no things to repair in their home. In other words, these three facts were adverse to the claims. They also said they had no time for lunch. They, on 5 of their invoices, when they said they were working, their vehicle said it was moving. Now, I'm not an appliance repair person, but I think repairing a refrigerator from a moving van could be fairly dangerous. The first invoice was in their driveway, according to their GPS. They clocked in late, clocked out late. They checked inventory 4 times while driving. They went to this spot we've been watching, this personal detour, and they claimed they worked after hours, and they didn't. Data was able to resolve all of the issues in the case and not only answer merits and damages, but establish the credibility, or in this case, the lack of credibility of the employee. This same day, seen graphically, looks like this. An employee who works not only hard, but extra hard. Not 8.5 hours, but 9.5 hours to service the company's clients because they need service. But when we compared that to what actually happened, it was a different story. Yes, eventually the employee went to all those locations, just not immediately. A lot of personal detours accomplished by sandbagging their invoices and their time entry. When we showed this to the mediator and opposing counsel jumped up and down and said, as you would, "This is an anomaly, Your Honor. This does not represent a normal day." We said, well, it's not a normal day, but it's not an anomaly because the employee went to this unknown location in the upper right-hand corner 243 times in 6 months. This was a pattern in practice. We were able to find fatal flaws in each of the employees through data analytics. After 5 depositions, no one else would even show up for deposition. So the question is, do you have cases that involve data? And if so, how would you apply data to your cases? I've been asked that question several times over the last 2 years, and so today, for the first time, I'm going to roll out for you a methodology for using data in your cases. How to become data savvy, and how to fact crash your cases. Fact crashing. What is fact crashing? I made the term up, so let's just tell you what the definition is. Facts, the truth about an event opposed to an interpretation, is reflected in digital information. And to crash, this is a project construction term. It's the compression of project activities to deliver results in sooner than originally planned. It's to accelerate the critical path of a project. And what we find is, rather than delaying data, structured data, till much later in a case, or as most litigants would prefer, never, instead we can accelerate the acceptance that data is playing a role, it is viable evidence, and use it to determine facts sooner, resolve issues sooner, and save substantial money in discovery. How do we do that? Well, the traditional way was to gather information and treat it all individually. Today, we can take information and combine it, as you saw with the time card of that employee, and layer data to tell more complex stories or more granular stories. This is different than traditional discovery because documents, which is what we understand, which is what we have the tools for, and is what the courts expect, are also very expensive, they're labor intensive, and they're voluminous. We're talking about techniques this morning to get through documents without having to read them all because we simply don't have the time and the resources. But with data, if we had the tools and the attitude and the appetite, can give much better results for much less money and much more objectively reliable. So let me give you some principles of fact crashing. And if I'm going a little bit speedy, it's because we have another spectacular lunch presenter in 10 minutes, Mr. Mattson. Fact crashing, 9 principles we've come up with to help anybody address the availability of data in their litigation. Number 1, data is evidence and it is discoverable. This is part of our Federal Rules of Civil Procedure. It's well documented in all our best practices. We have guidelines in the Federal Rules of Evidence that have been recently modified under FRE 902.13 and 14 for the self-authentication of data records and the copying of data records. Very, very much part of our jurisprudence. Number 2, data should be addressed early. Documents are difficult to gather. Data can be time-consuming to gather. Sometimes you have to go, oftentimes, to third parties who are controlling the Twitter account or the LinkedIn or the Fitbit data. So you may have to plan for subpoenas and additional court-imposed or rule-imposed delays. Number 3, frame your case issues as data-centric inquiries. This means your claims and defenses, your traditional law school prongs of a contract violation. Did you have a contract? Was it violated? Were there damages? Is that within the statute of limitations? I'll give you an example of an elder care home. The question is, was there reasonable care? How do you frame reasonable care as a data question? Well, what was the number of staff per patient? How many visits did the staff make on a given patient in a given day? What was the incident rate of illness or morbidity? These are data-based answers that we can extract from the systems that can inform us as to the conclusion of reasonable care. Identify and prioritize data sources. I talk to people all the time. How many computers do you carry? How many computers do you have? How many computers surround us? The answer is always smaller than the reality. Right now, I could ask you to raise hands, but I'll ask you to raise fingers. Do you have a cell phone with you? A tablet? A laptop? A smart credit card? A key fob? A door card that will open up your door? And we can go down the list. Do you have any thumb drives, which are actually little computers? You can get to 10, 15. I had one person get to 30 computers. Didn't even realize it. And I'm going to count the cell phone as a single computer, even though it's got multiple devices and sensors inside of it. In order to identify and prioritize data sources, I can give you also 3 tips. One is we have a 6-step method for walking through how to identify computers, either through personal experience, reviewing the pleadings, interviewing the employees. We make site visits. We follow employees. We call it the ride-along, or we do tabletop exercises. Somebody represents the municipality, somebody the employee, somebody the company. Which computer systems are being engaged through the course of a normal day? We also have the 5 A's of accessibility to assess data once it's been identified. Does that system have data that is existent, accessible? Is it affordable? Is it applicable to this case? And will we be able to admit it into evidence? And the 5 C's of reliability. What caused the data to be captured? Was it captured by a device or by a human? Is it numeric structured data or unstructured? Is it directly controlled, indirectly controlled, or third-party controlled, i.e. can it be compromised? And are there other data sources we can use to cross-index and correlate this data? A concept that one of my clients, Denise Backhouse, refers to as pseudo-blockchain. Data can confirm data. Principle 5, data may be subject to preservation, privacy, and security obligations. Act accordingly. Principle number 6, data reliability starts with the proper collection. We need to document structured data much more than we document email because there's a lot of moving parts. Fewer people actually understand the systems. We've been working with email for 15, 20 years now. On an average day, I'd give us about a C-. I have a client with 1 email system but 10,000 databases. I would not want to give them a letter grade on their database capabilities. Collectively, it's low, but individually, there are people who know it. Principle number 7, data analysis understanding is required for proper analysis. When you receive structured data, it's more important that you profile it, that you validate it, that you verify it. Specialized training, in-depth interviews, and/or data testing can be useful or necessary, but the results can be transformative. Principle number 8, structured data can shape your other discovery. We are now using structured data to dramatically change the scope of document discovery. We're using the context and the transactions that are contextual to better inform on a custodial by custodial basis what the date ranges are, what the locations are, what the content might be for certain employees, or what the dates of interest are. It is significantly cheaper to look at 1,000 dates, 1,000 days of transactions in a general ledger system to find 5 days of interest to read 5 days of emails than vice versa. Principle 9, we use data to work toward early resolution, not to work toward trial. We can resolve merits issues, damages, in the case of the employee's credibility, class cohesiveness, discovery compliance, depositions, and more, and look at each of those as inflection points where we can reduce the issues on the table and move toward resolution. And I would suggest if we move toward resolution faster, we could relieve some of the congestion in our dockets, the cost of litigation, and give us opportunities to resolve issues that have not been adjudicated but deserve adjudication. So in summary, these are the 9 principles. I hope you find this informative. It's been transformative for us. And remember that no one is data poor. Everyone has data, even if they don't have emails. Get an early start and ask yourself if you want superior outcomes in terms of accelerated resolution, reduced costs, strategic advantages, fact crash your case. Thank you very much.